A word now about Section 80, which is headed Majority Ownership. This heading is completely misleading. It is providing that there should be a minimum of solicitor ownership of 10% in place of the existing 51% minimum under the 2010 Act. We're talking here about the Legal Services Scotland Act 2010. The SLAS position is unchanged in that independence should remain a key guiding principle and duty in the profession. The Scots Government put independence as a guiding principle in Section 4 of the Bill, but they do not seem to understand what it means. Scottish Law Agents Society would urge solicitors to think long and hard about agreeing to allow their practices to become such an ABS, alternative business structure, with external control and especially in view of the totally inadequate suitability test. There is a suitability test set out in the 2010 Act, and it may possibly have been sufficient when the minimum percentage that a solicitor owned in their own firm was 51%. But the suitability test is now totally inadequate when the minimum is only 10%, and I'll explain why. It just isn't fit for purpose. It raises huge concern over the possibility of money laundering and criminal control of the ABS structure or model. Point 1. No suitability test is required for holders of less than 10% of the firm. Example, 10 holders of 9% do not need a suitability test at all. They could be part of a criminal gang with various family and associates holding the shares. This is completely open to abuse and does not square with the aim of AML legislation and requirements. Suitability tests should apply to every applicant, no matter the percentage share of the holding. Second point, the Law Society or other regulator are to be tasked with determining suitability, but unfortunately lack and are not given the tools to do so. For example, the Law Society should be obtaining a disclosure report in respect of criminal records of all new outside owners. Such information is not publicly available and is protected, so we need this power. Another point, there should be provision that the onus of proof of being suitable is on the applicant. The problem with the suitability tests is that in practice the onus would be on the Law Society to prove the person is unsuitable. And that's difficult. If it's refused by the Law Society, then there's every likelihood of a successful challenge under human rights legislation, which will be potentially very expensive and need concrete evidence to resist. So we feel that putting the onus on the applicant should assist. The applicant should require to prove that they are suitable and require to provide all evidence as to their suitability. Also, they should be required to give information as to family members and associates, if requested by the Law Society, with consent from each of the family members and associates to allow the Law Society to require similar searches of criminal records of those family members and associates. Failure or delay to do so should result in refusal of the application. This puts all the onus on the person wanting to provide funds to be in good faith and show why they are a good person and suitable to be a person owning a legal firm. And the Law Society or other regulators will require the right to demand details of the names of all relatives by blood or marriage or civil partnership or live-in partners and associates from the applicant. Failure or delay to do so should result in refusal of the application. Another aspect to this is that we are not aware of the government considering the AML position at all, or having issued a risk assessment for this substantial change with potential negative consequences, and whether it is possible to take mitigation measures, and if so, what measures are required to avoid AML implications of the change. We have done that exercise as above, but the government just haven't done their homework on this, and it really is not impressive. AML risk assessments are something that are required by the profession all the time. They're required of the Law Society and others. The government should have done its own risk assessment of this very legislation and opening up ownership to outside parties where this could be money flowing in. I should mention some of the other notable changes that have been made. For freedom of information, Category 1 regulators, which include the Law Society and any others that are authorised, they're subject to FOI legislation. I don't think this is a desirable change. The SLCC accounts, audit and supervision of SLCC accounts, there's no provision for scrutiny. And this has been a problem. SLCC have been making well above average increases in the cost of living. And that's been happening for a number of years. And they don't appear to need to control their budget. We as a profession are just to pay what they say is due. Now, we've said in the past that Audit Scotland should approve the draft annual budget of the SLCC. Proper accountability is not compatible with the SLCC or any organisation, especially a public body scrutinising itself. There's another change that they have, and that's time limit for prosecution of certain offences under the Act here, which is welcome. They say that proceedings for certain offences may be commenced within a period of 6 months, beginning with the day on which relevant evidence came to the prosecutor's knowledge, and no such proceedings may be commenced more than 2 years, A, after the commission of the offence, or B, in the case of a continuous contravention, after the last day on which the offence was committed. Now, it's sensible to have these kind of provisions. If continuous contravention, the complaint may specify the entire period during which the offence was committed. But the 2-year time limit for offence proceedings should also be made to apply, surely, to the time limit for making complaints, which is at the moment 3 years. That should be reduced to 2 years, surely, for consistency. There's no reason for there to be a difference. I imagine 2 years has been taken because it conforms with other laws for other organisations in general and these proceedings. So why is this 3 years? It should be set at 2 years instead. Anyway, thanks for listening to me. There are more changes and more to this seminar to be given by another party, and I'll just hand over to them now. Thanks.